will be discussing criminal law and criminal procedure for our MEE Highly Tested Issues Guide. First things first, let's talk about the frequency and how you can expect criminal law and criminal procedure to appear on your exam. Criminal law and procedure appear consistently on the MEE, but it is less tested than some other MEE subjects. It's tested on average a little less than once a year. Generally, the MEE tests criminal law or criminal procedure. While the subjects have been combined before, usually one or the other is being tested. Additionally, criminal law and criminal procedure are tested with about the same frequency. So the chances of seeing a criminal law question are about equal to that of seeing a criminal procedure question. In the past, the examiners have combined criminal procedure with evidence. Both times they've done this, it was a Miranda issue tested with a hearsay issue. Next, you should be aware of the highly tested criminal law and procedure issues. Turning first to criminal law, specifically the topic of homicide. Homicide is the most highly tested criminal law topic. The great thing about this is you already have to familiarize yourself with it and really understand it for the MBE, because the examiners tell us that we receive 3 to 4 questions on homicide alone. So by learning and memorizing homicide, we are really preparing for both portions of the bar exam. The most important thing to understand about homicide are the distinctions between first-degree murder, second-degree murder, felony murder, voluntary manslaughter, and involuntary manslaughter. One thing that is worth pointing out relating to homicide MEE questions is that in the past, when they've tested homicide, what they really like to do is for examinees to explain and to evaluate the crime by dividing the crime up pursuant to the 4 basic elements. You will notice that the examiner's analysis breaks up their answer this way as well. So the 4 basic elements of every crime are guilty mind, guilty act, causation, specifically actual and proximate cause, and concurrence. This means your defendant must have had that guilty mind at the time they committed the guilty act. It's also worth noting that the examiners really like to get into the nitty-gritty of causation. So in your analysis, be sure to break down and separate actual causation from proximate causation. In the past, homicide questions have tested involuntary manslaughter. And this makes a great question because the mens rea is different depending upon the approach taken by a jurisdiction. Some jurisdictions require gross negligence, which is a minority, and the others, the majority, require recklessness. So if you see this tested, be sure to explain that jurisdictions take different approaches. Be sure to define those terms. So gross negligence is present when an ordinary person in defendant's position would have been aware that her conduct created unreasonable risk of death or serious bodily injury. Recklessness is a conscious disregard for a known risk. Then in answering this type of question, you should move on to analyzing if either or both mens reas are present. Our next highly tested criminal law issue is the defense of insanity. The most frequently tested insanity test on the MEE is the McNaughton test. This is a difficult test for the defendant to meet. The law states that this is when the defendant has a disease of the mind, which caused a defective reason, and the defendant lacked the ability to know the wrongfulness of his actions or to understand the nature and the quality of his actions. For example, let's say a defendant has a mental illness and thinks that his friend is a plastic mannequin. Defendant starts shooting his friend and ends up killing him. If defendant sets forth the defense of insanity, he would pass the McNaughton test. This is because if his friend really was a plastic mannequin, then shooting the mannequin would not be a crime. Let's turn next to criminal procedure issues. The most highly tested topic on the MEE in criminal procedure is the Fifth Amendment. You should try to know Miranda from top to bottom. So to start, you should know when Miranda warnings are needed. Someone has a right to be Mirandized when they are subject to a custodial interrogation. And you should memorize those buzzwords and use them on an essay that tests this issue. For a custody analysis, ask yourself, would a reasonable person feel free to leave? You should consider things like the duration of the questioning as well as its location. If a reasonable person would feel free to leave, then the defendant is not in custody. As for interrogation, This is the questioning initiated by law enforcement officers or its functional equivalent. Another area of Miranda to be familiar with is how someone can waive their rights. In order for a waiver to be proper, it must be knowing, intelligent, and voluntary. Again, these are great buzzwords to memorize and to use if this issue gets tested on an essay. Next, to invoke your Miranda rights, one must be explicit, unambiguous, and unequivocal. So, one must say, I want a lawyer, not, I think I need a lawyer. When someone invokes their right to counsel under the Fifth Amendment, it must be clear and unequivocal. Again, saying something like, I want a lawyer. Once this happens, all questioning must stop unless the suspect initiates it. Additionally, this lasts for 14 days after the suspect is released from custody, so long as a waiver is received. Now, if there has been a Miranda violation, then the statements are excluded from the prosecutor's case in chief, but any physical fruits can be admitted against the defendant, so long as those statements are voluntarily made. To give you an example, a defendant was not properly given Miranda warnings despite being in custody and being interrogated. The defendant confessed to murdering a victim and stated, "The weapon is in the cellar of my uncle's basement." The prosecutors thereafter recover the weapon. The defendant's statements could not be admitted against him in the prosecutor's case in chief. However, the physical fruits in this case, the weapon, could be, assuming the defendant had made those statements voluntarily. The 14th Amendment and 6th Amendment have also been tested on the MEE, but not at that same frequency as the 5th Amendment. Nonetheless, it's good to be familiar with those concepts as well. The next highly tested topic in criminal procedure is the 4th Amendment. The 4th Amendment prohibits unreasonable searches and seizures. And while the 4th Amendment is dense, it has appeared frequently, so we recommend that you review it. Some things that we specifically want to mention. You should know when the 4th Amendment applies. It applies when there is a search or seizure by a government agent, when the person has a reasonable expectation of privacy. Valid warrant requirements. A warrant is valid if it's issued by an unbiased magistrate and is supported by probable cause and particularity. Finally, be familiar with warrant exceptions, especially those of consent, plain view, and exigent circumstances, like hot pursuit. Our next tip for doing well on criminal law and criminal procedure MEEs is to learn the basic definitions and introductions to each topic. This is a good thing to get in the habit of doing because it's going to build credibility with the grader and it will help you accurately apply the law to reach a conclusion. I won't cover every example provided in the guide, but to touch upon a few. Malice aforethought. This is a legal term of art, and it's applicable to murder, and it encompasses different mental states. In most jurisdictions, it's satisfied if the defendant acted with the intent to kill, with the knowledge that his acts would kill, with the intent to inflict great bodily harm, or with reckless disregard of an extreme risk to human life. Another example, interrogation. This is defined as any words or actions on part of the police that the police should know are reasonably likely to elicit an incriminating response from the suspect. For example, it's likely an interrogation if the police say, "Your accomplice has already confessed, and they told me the role that you played in the murder." It's likely not an interrogation if a police officer asks, "What's your address?" Now, our final tip for you to do well on criminal law and criminal procedure MEE questions is to practice. We have given you some insight into how some of these issues are tested, but you're going to learn best by practicing and getting exposure. Additionally, as an added bonus, your MBE score will likely improve as well. So that wraps up criminal law and criminal procedure for the MEE Highly Tested Topics Guide.